Wait lang, start na ba? Chapter, ay wait lang. Jonah, good afternoon, Sir Bernardo Masangkay. Good afternoon, fellow classmates. I, together with my co-presenters, will report about the Chapter 3, the solution and winding up. Next. Article 1828. The dissolution of a partnership is the change in the relation of the partners caused by any partner ceasing to be associated in the carrying on as distinguished from the winding of the business. So next. So before I proceed in my real topic, let us first define the words that are needed to be defined so we can understand all what we are going to talk about. So when we say dissolution, it is the change in the relation of the partners caused by any partner ceasing to be associated and the carrying on of the business. It is at this time that the partners stop operating the business together. It also symbolizes the dissolution of a partnership. Another word is winding up. It only means that it is the process of settling the business or partnership affairs after the dissolution. Lastly is the termination. It's that point in time where all the partnership affairs completely wound up and finally settled. It also denotes the end of the relationship's existence. Next. Article 1829. On dissolution, the partnership is not terminated but continues until the winding up of a partnership affairs is completed. Next is partnership not terminated by dissolution. It also says that a partnership's dissolution should not be interpreted as its extinction. So the principal significance of this solution is that thereafter, no new partnership business should be undertaken, but affairs should be liquidated and distribution made to those entitled to the partners interested. In additional, up until the winding up is finished, the partnership remains in effect. Dissolution then refers to a change in the nature of the partnership relationship rather than the actual closure of the partnership's operations. And of course, the solution of a partnership must also be distinguished from a mere suspension in the conduct of its business or its operations. Next. So in Article 1813, dissolution is caused, number one, without violation of the agreement between the partners. And then in this number, it has a specific topic, letter A, by the termination of the definite term or particular undertaking specified in the agreement. Letter B, by the express will of any partner who must act in good faith when no definite term or particular undertaking is specified. And then letter C, by the express will of all the partners who have not assigned their interests or suffered them to be charged for their separate debts either before or after the termination of any specified term or particular undertaking. And lastly, by the expulsion of any partner from the business bona fide in accordance with such power conferred by the agreement between the partners. Next slide. Number two, in contravention of the agreement between the partners, or what we called by the express decision of any partner at any moment, where the circumstances do not permit a dissolution under any other provision of this article. Number three, by any event which makes it unlawful for the business of the partnership to be carried on or for the members to carry it on in partnership. Number four, when a specific thing which a partner had promised to contribute to the partnership perishes before the delivery, in any case by the loss of the things. However, the partnership shall not be dissolved by the loss of the thing when it occurs after the partnership has acquired the ownership, where the partner who contributed it. having reserved the ownership therein, has only transferred to the partnership use or enjoyment of the same. So number 5, by the death of any partner. Number 6, by the insolvency of any partner of the partnership. Number 7, by the civil interdiction of any partner. And lastly, by the decree of court under the following article. So next slide. Causes of dissolution. So it outlines the statutory grounds for dissolution in Articles 1830 and 1831. So there are further causes listed in Article 1840. So number 1, without violation of the agreement between the partners. So it basically means that it should be emphasized that dissolution can occur both in compliance with and in breach of the partner's agreement. Number 2, voluntary or involuntary. So it may be voluntary when brought about by the will of one partner, more than one partner, or all of the partners, or it may be involuntary when brought by an outside force or the operation of law. Number 3, extrajudicially or judicially. So a court order or an judicial method can also be used to dissolve a partnership. And lastly, automatic dissolution. So it will also be noted that the partnership dissolves automatically for the reasons listed in Article 1830. So it has also been said that upon the dissolution of a partnership, the original partners may create a new partnership to carry on the business under the same conditions. Next. Dissolution effected without violation of partnership agreement. So there are four ways by which a partnership may be dissolved without violation of the partnership agreement. So first, termination of the definite term or particular undertaking. So it basically indicates that a partnership may be formed for a set period of time or with a specific endeavor as its aim. After the expiration of the term or particular undertaking, it also says that the partnership is automatically dissolved without the partners extending the said term or continuing the undertaking. So number 2, by the express will of any partner. So this indicates naman that as long as the partner in question acts in good faith, a partnership at will may be dissolved at any moment by any partner without the approval of his co-partners and without the breach of contract. So each partner has the authority and the right to end the partnership at any time in this form. So number 3, by the express will of all the partners. So in these third ways, there must be unanimous consent to dissolve the partnership before the end of a specific period of the particular endeavor. So it further clarifies that the partnership cannot be ended by the majority acting alone without violating the contract. So lastly, by the expulsion of any partner. So the expulsion must be in good faith and in accordance with the authority granted by the partnership agreement between the partners. However, the partner expelled in bad faith can claim damages. Next, the solution effected in contravention of partnership agreement. So first is the solution may be for any cause or reason. It indicates that even though the partnership was formed for a specific term or specific project, any partner may dissolve the partnership at any moment without the approval of his or her co-partners at his or her sole discretion or for any reason. Number 2, power of the solution always exists. So the delectus personae theory gives a partner the authority, but not always the right, to end a partnership even if his fellow partners want to keep the company going. Number 3, legal effects of dissolution. So in the event of an unauthorized dissolution, the withdrawing partner is liable naman for damages. Next. Business becomes unlawful. So dissolution may be caused involuntarily when a supervening event makes the business itself of the partnership unlawful or makes it unlawful for the partners to carry it on together. And a partnership must have a lawful object or what we call a purpose. So next, loss of a specific thing. So this provision of Article 1830 refers only to specific things. First, loss before delivery. So if the specific thing to be contributed by a partner is lost before the delivery, the partnership is dissolved because there is no contribution in as much as the thing to be contributed cannot be substituted with another. Number two, loss after delivery. If the loss occurred after the delivery of the thing promised, then the partnership is not dissolved. Number three, loss where only use or enjoyment contributed. So if only the use or enjoyment of the thing is contributed, the partner having reserved the ownership thereof, the loss of the same before or after the delivery dissolves the partnership. Next. Death of any partner. So it says that the deceased partner ceases to be associated in the carrying of the business. Consequently, his passing caused the partnership to dissolve. So according to this clause, the surviving partners are only permitted to carry on with the company as far as is required to wind it up. So, insolvency of any partner or of a partnership. Number one, if a partner is insolvent, his interest in the partnership is subject to the right of his creditors. And if the partnership's assets have been exhausted, he is unable to fulfill his duties to the partnership's creditors. So, an insolvent partner has no authority to act for neither the partnership nor the other partners to act for him. Number two, the insolvency of the partnership renders its property in the hands of the partners liable for the satisfaction of partnership obligations. That is making it impossible for them to keep the business going, which effectively amounts to dissolution. Next, civil inter civil interdiction of any partner. Can we go back to that slide? Civil interdiction of any partner. So a partnership requires the capacity of the partners. A convicted person suffering from the accessory penalty of civil interdiction cannot give consent at his capacity to act is limited thereby. So according to the law, civil interdiction denies the person serving a sentence the liability to manage his property and dispose of it by any act or conveyance that would take effect during the person's lifetime. So may I call on the next reporter? May I call on Miss Cheryl Lavado? O sige be. Nasaan ba si Cheryl?